And we're really privileged and lucky to have Mr. Sussman here today, and you're going to learn a lot about juries. You know, listen, I think probably most of us, where are the jurors that we're appreciating today? Can we just see a show of hands? So there. And then how many of you have ever served as a juror? I know I have. I have twice when I was a lawyer. So I know that all of us in this room know and appreciate how important jury service is. And so for the jurors who took the time today to be here, we truly appreciate you. I would say that this is a room full of people who knows and recognizes that despite the fact that the bedrock of our democracy is jury trials, that it is very difficult to get citizens to come in and do that civic obligation. Diane Ferry is here, and she runs the jury office, and we owe her a great round of applause. As chief judge, I talk to Diane at least weekly. And I mean, here's an astounding statistic for you. If Diane sends out 1,000 notices for jurors to come in and serve, what do you think the yield is? That would be the amount of notices that go out, 1,000. How many people do you think we end up with out of that 1,000 to select jurors for all 54 judges? How many people do you think show up? The average is 23%, and on many days it is far less than that. So that is something that we are always trying to figure out, the perfect balance of how many people to subpoena and how many people are we going to end up with. And Diane does an incredible job making sure that all of our courts get covered. I know that we're all patriotic and know how important the jury system is. And I know that Mr. Sussman is going to talk to us about how there is just a great decline throughout the nation with jury trials. I don't think that's true in the 15th. In fact, I know it isn't because I get the trial stats. And our trial judges, as I was telling Mr. Sussman, much to his surprise, are trying 1, 2, some judges are trying more than 2 a month. And so evidently that's a much higher statistic than is happening nationally. And I think by virtue of the fact that there's so many of you here today, that you also know and appreciate the great importance of the jury system, that how many lives and blood has been lost for us to have the democracy that we have. I don't know how many of you have ever traveled to a communist country, but there's nothing like doing that to make you appreciate what we have here in America. So hopefully everybody will learn a lot about what we can do to improve our jury system, and I would ask all of you to think about what we can do to improve the yield, that meaning, you know, citizens who come in, because I know that every judge goes through great effort when they get a group of jurors in there to stress how important this is to our democracy. And short of military service, there is no greater duty that you can give to your nation than serving as a juror. So again, for those jurors that showed up today, we truly appreciate you, and we appreciate you performing your civic obligation. Judge Sharon Bach is going to address you for a few moments. Thank you so much for being here today.
Thank you.
Luckily, I'm an athlete and can make it up without steps, right? And thank you for the moniker of judge. I appreciate that very much. But I am the clerk and comptroller, Sharon Bach, for those of you who do not know me. And I definitely want to thank all of the judges in the room, especially our wonderful chief judge, Judge Krista Marks, for not only the relationship that we have between the clerk's office and ourselves, but just for the incredible job that our judges and our do every single day in Palm Beach County. So let's give them all a hand. You know, it's my privilege to be a part of this important event where we're not only honoring our jurors for their service, but we're really celebrating the jury system designed to protect our civil liberties. You know, each day in courtrooms across America, our Constitution comes alive when we receive our jury notice, and you, as jurors, take that as a call to action, a call to duty as a citizen of this great nation. Democracy works because decisions are not concentrated in one person or in one place. This fundamental principle, as we all know, is called separation of powers. My responsibility as the independent and independently elected arm of the judicial system is to actually create a fair and level playing field. We do that by summoning the jurors. In Palm Beach County, as Judge Marks indicated, we actually summons about 173,000 people by calling on their driver's licenses that is in a database. Our goal is to ensure that the lawyers and the judges have enough jurors so when they interview, accept, or release a juror, there is another citizen who can be interviewed for the jury selection process. As the judge said, this is a very complex calculation, and it is called yield. Part of my job is to work with this yield and to constantly look for ways in which we can increase it. My team and I, and she already introduced you to Diane Ferry. Di, stand up. And Louis Tamayo, where is Louis? Did I see him here? Oh, there's Louis Tamayo. Okay. These are the people who you can call on, if, especially you as lawyers or judges in the room can call on if you ever have a question about the jury system in Palm Beach County. But I want to tell you, not only do we summons you, but, and I hope your experienced jurors were this, and that is we try to make it as convenient and comfortable for you as possible. I really look forward to our discussion today, and thank you very much, jurors, for your service. Thank you, all of the lawyers and the judges in the room, for making this wonderful democracy through our judicial system work. Thank you.
Thank you. Thank you, Sharon. Good. Careful.
Okay, good afternoon, everyone. I'm Lisa Small. I'm one of your circuit civil judges. So while we are here thanking our jurors for their sacrifice and their service to our community and our country, it's also equally important that we thank them for their feedback today that they're going to give us in order to help us improve our civil jury system. Jurors all across this state each day are determining cases that run the gamut of human experience, from personal injury cases to business disputes, real property disputes, employment law. It cannot be overstated the importance of the right to trial by jury in civil cases. Our founding father, Thomas Jefferson, once observed, and there are lots of quotes from lots of people over the course of history concerning the importance of the right to trial by jury. But Thomas Jefferson, he observed, "I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its Constitution. Trial by jury is part of the bright constellation which leads to peace, liberty, and safety." Thank you to all of our jurors for serving our country.
First of all, welcome everyone. I have the privilege of introducing Mr. Sussman, Steve Sussman. Steve is one of the preeminent trial attorneys in the country. The National Law Journal said he's one of the top 10 plaintiffs' trial lawyers in the United States and has one of the most successful law firms. Steve does not have to do this. He does this at NYU Law School to help us preserve this and protect the Seventh Amendment and protect the right to civil jury trials. So I wanted to thank Steve for being here and thank him for all he does nationally for our jury system. Steve Sussman, everyone.
Thank you. Thank you very much. The Civil Jury Project at NYU Law School was established 3 years ago to be the only academic center in the country that asked the question, why are jury trials, indeed all trials, disappearing? Should we be concerned? And what, if anything, can we do about it? It is truly amazing that a right that was so important to our founding fathers, that it's mentioned 5 times in our founding documents, the Declaration of Independence, the Constitution, 3 of the Bill of Rights, that a right that is so much part of the architecture of the justice system in this country that every courthouse, every courtroom has a jury box. And yet, all trial lawyers know, and most judges know who have been on the bench a long time, this is a 55-year picture of the number of jury trials per authorized federal judgeship. It's easier to get federal statistics than it is to get statistics on a state-by-state basis and make them comparable. But this trend of declining jury trials, so that last year, the average federal judge in this country tried about 2 jury cases, civil jury cases, and under 2 bench trials, is an astounding kind of picture. What I did not know when I started the Civil Jury Project was that bench trials have fallen even quicker than jury trials. That means if we don't do something, public dispute resolution in this country is just going to disappear. Yes, people will continue to have disputes. They will resolve them through private judging out of the public eye. But how about the public courts? Don't we have to keep them healthy and vibrant? And this is a pretty poor picture. And the fact that bench trials are going down quicker than jury trials makes most of the arguments about why jury trials are declining wrong. Some people say they're too expensive. Jury trials are too expensive. Well, more expensive than what? Bench trials? Not at all. Jury trials last too long. Longer than bench trials? Not at all. Jury trials, a jury verdict is too uncertain. There's a danger of jury runaway verdicts. No, there's a tremendous, like 85, 90% agreement between judge and jury every time a verdict is returned. The empirical research proves that. And I don't think any special skills are needed to try a jury case rather than a bench case. So you cannot explain this decline in public dispute resolution by saying there's something special about a jury. Yet there is something special about where we are today. As I go around the country, this is the 27th luncheon like this we've had around the country. More judges and more lawyers have showed up at this luncheon than anywhere else in the country. So that's something, says something about where we are standing. If you look at the statistics for the Southern District of Florida, they rank 12th of all the districts in the country in the number of jury trials and 11th for the most bench trials. That means that something's going on here a little different, and there is a cultural difference between parts of the country. This is a statistic that's even more telling because this takes account of the decline in the number of cases filed. This is the percentage of cases that are disposed of by jury trial as opposed to some other means, summary judgment, motion to dismiss, something. And again, you can see that the percentage of cases in federal courts last year, it was about 0.5% were disposed of by either bench or jury trials. And again, it's the long period of time, the trend. People say, well, maybe the state court's different. Look at we've got the statistics for the whole state of Florida, but you can see what's happening in the state of Florida in the last 17 years, a decline. It seems to have jumped up a little in 2017 in the number, and that's a percentage of cases resolved by jury trials. So the statistics are terrible nationwide, and one of the things we ask is, well, what can we begin, how can we do something about this? We began by trying to say, and I think we were right in concluding, that the way we're going to save jury trials in this country are judges. If the judges lose interest in trying jury cases, or unfortunately, if the judges lose the skill to try jury cases, that is a horrible thing to happen. And you know, and I know, and I don't know what's happening in Florida, but it sure is happening in the state of Texas where I'm from. Increasingly, judges are getting appointed, certainly to the federal bench, who have never tried a case before. There are new judges in Texas that have never even seen a jury trial. And I went to meet Monday with a federal judge, Tom Martin from Kansas. We went to meet with the head of the Federal Judicial Center, the educational wing of the federal judiciary, about the program. What kind of education are you giving to new judges about trying cases? And I'm sorry to report that it's hardly anything. They go to these schools and they learn about disposing of cases, clearing their docket, being efficient, but not about actually sitting on the bench with a jury in the box and what to do to try the case. And so if a new judge is presented with the opportunity, do I either decide this on a motion or do I have a trial? And that judge does not have the experience or the education to try a jury case, what do you think they're going to choose? It's going to be disposed of on the papers, not with an actual trial. So we need to focus on educating the judges. We have 275 judges around the country that are now judicial advisors to the Civil Jury Project. We add to that 65 academics who have done research in how juries work and the history of the jury trial. And we even have 35 jury consultant advisors that are helping us do some simulations and studies about how we can improve jury comprehension. We have engaged in a bunch of empirical research at the Civil Jury Project. One of the reasons I think these lines are on the downward trend is that no one but people like us is aware of them. 80% of the people in this country who are not lawyers, we did a survey, think that the number of trials in this country in the last decade has gone up. That's wrong. The statistics show that's not right. What is causing this misperception that our courts are busy? You can go to most courthouses in this country, state and federal, unfortunately, and shoot a cannon through the halls on a weekday and not hit anyone. The courtrooms are dark. Many of them are dark. The judges are working, but not with the lights on and a jury in the box. So we need to change that perception of what's going on, because if people are not aware that trials are disappearing, no one will do anything to do something about it. We studied all of the major material contracts that businesses that are public enter into with each other. Those contracts have got to be filed with the SEC in an 8K as soon as they are executed. So we looked at all of the contracts filed with 8Ks with the SEC during a 6-month period of last year, and we looked at those contracts to see, do they have a jury waiver clause or a mandatory arbitration clause? To our great surprise, 57% of those contracts do not contain either, which suggests that the majority of American businesses, when dealing with each other contractually, are happy to resort to juries and the public courts to resolve their disputes. I expected it would be a much smaller number than 57%. And we began calling the general counsel of those companies and recording what they were saying to us. We're going to come out with a publication on that shows that many general counsel of American companies are now unhappy with arbitration as a way of resolving disputes. It's too expensive, there's no appellate rights, it takes too long, arbitrators split the baby. It's not less expensive in terms of discovery or anything else. And there's no appeal. So that was some research that was very helpful. And then we are proposing a whole bunch of innovations. So what we figure, well, there are few jury trials, but at least we can make them better. Better for the jurors, better for the litigants, better for the lawyers, and even better for the judges. We have conducted now 5 full-day workshops at NYU, where we invite state and federal judges to come to NYU at our expense and sit around a seminar table for a day and talk about the care and feeding of jurors, jury selection, jury comprehension, and training of advocates. Because if we don't train jury trial lawyers, they will go away. A lot of judges say, I'd be happy to try more cases, but the lawyers don't want to try them anymore. They don't know how to try them anymore. They'd rather go to mediation, have the case settled, put the money in the bank, than go take the chance that a jury will not give them anything. So we have done one of the ones we had in the spring. Judge Sasser attended. By the way, Judge Sasser received the first Jury Innovator of the Year award from the Civil Jury Project. Judge Sasser, that was... We have published a monthly newsletter, which you all have copies of, and since you are here today, you will be on our mailing list and will get continued copies of our newsletters. We have created and maintained 2 websites. One website, the Civil Jury Project, that's for lawyers and judges and academics. And it has a lot of material and it changes all the time. Every one of these 27 lunches now has a video. We pay for a video to be made, and they are put on this website so that information can be shared around the country about what things are happening and how to improve. We have a separate website called WeThePeople, and this is a website designed to deal with the 20% problem. The fact that of all jury summons around the country, the average yield is about 20%. You're not low or high here in Palm Beach County. It's about a 20% response. So we want to get people, the function of this is 2. If you have served on a jury before, we ask judges to distribute to jurors this card which says, you can talk about your experience. We've had hundreds of jurors go to this website and fill out a questionnaire answering the same questions I'm going to put to the 5 jurors who you're going to hear from today on the panel discussion. And so we have that from those jurors. When we get a juror who's particularly articulate, we call them, we visit with them, and we ask them if we can videotape them. We tape their testimony. Every juror who talks to us loves. We've never seen a juror who hates the experience. I'm sure there are some, but they aren't raising their hand. They're not coming forward to either lunches like this or to our website. But the people we get love the experience. And then the second part, if you go on the left, that little thing that says receive a jury summons, this is where most of the hits on this website come to. And they're from people who have received a jury summons and are searching the web to see how to get out of serving on a jury. And I mean, if you just go to YouTube sometime and put in jury duty, and you get a lot of kicks because it's pretty funny, some of the videos on YouTube. But no one's trying to encourage, you can't find a video up there that encourages you to go to jury duty. And the point is, when someone comes here, they receive a summons, they immediately see jurors around the country, little video snippets of jurors around the country say, you just got a summons, don't throw it away. You're about to have the best experience of your life. Please go. It's patriotic. And I loved it. And I loved it because I met different people. And it was fun deliberating with all kinds of people who I'd never had to work with in my life. And it was fun to see how the judicial system works. And we get people to go to there by being active on social media, where people find us and they go there looking to get out of jury duty. And if people hit on the middle currently serving on jury duty, say, you shouldn't be here, the judge told you not to be here. When you finish, come back. And so it's been a very active website. And there is an unsatisfied desire out there of people who have been on juries to talk about their experience. You know, if you stay at a Holiday Inn last night, there's a form to fill out about how you liked your experience. If you go to a restaurant now, you are given a form to fill out on OpenTable about how good was the meal and the service and everything else. We are not systematically in this country giving jurors an opportunity to make the same kind of comments and criticisms about serving on a jury. And so part of what we're doing in the project is to provide that opportunity. When I finish showing you this very quick film, I'm going to ask the judges and jurors who have agreed to be on the panel today to come forward. But this this is something that each of you should have or you can get, and I certainly sent it to the judges on the panel. We listed about 18 different reasons for, and it may be on your table, why the jury trials are in decline, and we categorize them into two categories. On the left, those difficult to change, you need a statute or something like that. And on the right are the things we can do something about, like the expense of discovery, delay in getting to trial, judicial insistence on mediation as a precondition for a trial setting, lack of real trial lawyers, lack of real trial judges, which is insufficient judicial education, et cetera, et cetera. What we are dealing with today, what we're going to do the rest of the day, is how we can improve the few trials that are left so that both the litigants that are in it, the lawyers, think that the jurors did a better job, and the next time they have a dispute, want a jury to resolve it.
Thank you for coming. Now, I realize that you were summoned to this class without signing up for it, and you haven't even been told what this class is about. Nevertheless, let me tell you what the rules and procedures are. This course could take a few days or a few weeks. I'm not sure. This course could be taught by 10 or 20 different teachers, and it will involve a subject you know nothing about. In fact, if you knew something about the subject to be taught, you couldn't take the class. Each teacher will give you relevant information about the subject, information you'll need for the final exam. However, I will not tell you what is important and what isn't. Not only must you determine what is consequential or not, you must also figure out which teachers have told you the truth. And you can't take notes to remind yourself of what you've heard or what you thought was important. Also, you may not ask your teachers any questions, no matter how confusing the lectures are. Nor are you allowed to talk to your fellow students about anything the teachers have said, even though this is normally how you go through a college course, or life for that matter. And while it might be helpful to have a notebook for notes, course materials, or even an idea of what the final exam might be about, it ain't gonna happen. However, we will let you look at some of the materials while one of the teachers is lecturing on another important aspect of the course. Now, I won't be telling you what is important in this course or what the rules are for the final exam until all the teachers have given their lectures. When I do explain the final exam, I'll spend only 15 or 20 minutes on it. And I will probably use unfamiliar or technical terms that I will not explain. The final will involve only 1 or 2 questions. And you will have 1 sheet of paper to write the answer on. You can then discuss the course with each other, but bear in mind, you will all have to agree on the same answer to receive credit for the course. You will also be locked in this room until you reach agreement. Oh, and one more thing. Depending on your answer, someone you don't even know will either win or lose. Any questions? Good. Let's begin. This will be a rewarding experience for all of us.
So, now let's talk. That film, by the way, was produced in 1998. And that's 20 years ago. And in 2000, between 2000 and 2005, most of the major bar organizations, the American Bar Association, the American College of Trial Lawyers, and other bars, BOTA, made recommendations on dealing with some of the problems pointed out in this film. The interesting thing is, in spite of almost unanimity on what should be done to improve the situation, so few of those recommendations have been adopted to date. I sent something, we looked on the situation in Florida before I came here, and I gave it to the judges who were on the panel. Florida is actually pretty innovative and pretty far out in doing things like this. For example, every one of the jurors here, because it's a procedure authorized in your state court, was allowed to ask questions of the witnesses. That is something that is becoming very common across the country, but it's still in most federal courts it is not allowed, and in most state courts it is not allowed. But could we have the jurors who agreed to be on the panel come forward now? Ms. Nida, are you there? Mr. Hopkins? Yes, please come forward. Bradshaw, Borns, yes, and the judges too. Okay.
Just tell them to speak into the mic.
Yes. And please speak into the judges. Yes, thank Judge Maher. Okay. Nita is not here. So let me begin by, and I want to thank all of the judges for coming here today. Judge Maher, the federal judge who is here, and 3 state court judges, Judge Gill and Judge Curley, and Judge, and how do you spell your name? Artau? Artau. Artau. Everyone's got to speak into the mic so we can record it. So let me put the question to the jurors. I noticed no one, did anyone here attend a trial that lasted longer than a week? Well, your trial was, you were in the 8-day trial? The 8-day trial that should have lasted 4 days or 3 days? 1 day.
Sorry, guys.
And was a verdict returned in your case?
Quickly, yes.
15 minutes?
Less.
Less than 15 minutes.
Sorry, guys.
So, thank you. All of you were state court jurors, right? Now, one of you was an alternate. Who was the alternate?
I was the alternate.
You were the alternate. And your jury is deliberating as we speak.
Yes, given the complexities, I certainly hope so, yeah.
Mr. Hopkins, and were you the one in the mistrial?
No.
Oh, but the case settled.
No,
What happened in your case?
We had a verdict.
We
Oh,
had-
you returned a verdict?
Yeah.
And how long was the trial?
The trial, I guess it was 2 days, 2.5 days maybe.
Okay,
We were done, yeah, I guess 2.5 days.
and you deliberated how long?
Right after lunch.
Okay, quick. Mr. Bradshaw,
Yes.
were you in a case that returned a verdict?
Mistrial.
Mistrial after the first day,
Second day.
second day. And so you never even participated in a
No.
deliberation. So let me ask the four of you, when you got your subpoenas, had any of you been on jury duty before?
No.
You have been on jury duty,
Well, not down here, up north. And,
but you liked it before, so you came.
oh, it's great.
I've been called twice here and in another state, but never reached voir dire before.
Was anyone unhappy about being subpoenaed, summoned for jury duty? Did anyone go on the web and look for ways to get out? If your names had been provided to the lawyers in advance, we would have, unless some court had ordered us not to, have probably done internet research on each of you before we went to jury selection. And there's a lot we can find out on the internet about, all we need is your name to find out where you live, how much you pay for your house, are you a Democrat or Republican, what organizations are you in, and we don't even have to befriend you on Facebook to find out that information. If we were doing that, and most lawyers do unless the judge prohibits it, would that offend you, or is that something you would understand, it just happens? Mr. Schnurr.
I would understand it.
Mr. Hopkins.
Sure.
Mr. Bradshaw.
I'm totally fine with it.
Ms. Bournes, would you be okay with that?
Sure, you're just gonna be bored, but yeah, sure.
Okay, well, this is a hot topic in the country today because you go through the process at the beginning of the trial where the lawyers are allowed to ask you questions during voir dire and get your answers, and then the lawyers are given a chance to not only ask the judge to strike people who should be stricken because they know one of the parties or have an interest in the case, but the lawyers then get peremptory challenges to strike people from jury duty based upon whatever they base it upon. But what they hear you say about yourself. So if we got a lot of information in advance, that process might be quicker. We might be able to even do it before you come to the courthouse, exercise your challenges over them. But you understand that it will be a privacy issue. By the way, the judge told you not to use any of your electronic devices during the trial, right?
Yes,
Right.
correct.
Did the judge collect those devices, or were you allowed to keep them and use them during breaks? Does anyone remember? Did you have to give them up?
During breaks, we could
During
use them.
breaks, yeah.
During the breaks, but we left them
When you went into the courtroom, you left them,
we left them on the side.
okay? Yes, sir.
I have just one comment about your question about the internet now that I've thought
Yes.
about it. I don't know, not an attorney, not in the legal profession, but I don't know if there are, during voir dire, everyone could hear what the questions are. And if there are inappropriate questions during voir dire, the judge is there to regulate that. Just for being provided names, the attorneys being provided names and looks online prior to voir dire, it might speed up voir dire, but maybe there's information that's inappropriate to consider.
Okay. Was anyone upset with the way the voir dire was conducted?
No.
Do any of you think the lawyers were ineffective at finding out about your real biases and prejudices? You think the lawyers did a pretty good job?
Oh, yeah.
Yes.
At the beginning of your case, when you were selected to serve on the jury, did the judge give you substantive instructions? That's one that you saw that film where the professor, it's a fake film, obviously, but what they're trying to demonstrate is that in trials, typically the judge gives instructions at the end of the case. And the question is, wouldn't it be more helpful if the judge gave them to you at the beginning of the case than the end of the case? What do you think about that, Ms. Burns?
Well, how much is he going to disclose in the beginning? The whole point is to keep our minds open for the process. So by keeping us in the dark, we are supposed to be open-minded to everything that comes across the case.
Okay.
No.
Did Mr. Hopkins,
Gave a general.
Yeah.
you got a general instruction
At the beginning, yes.
about the burden of proof
Yeah.
and about witnesses, maybe how to judge the credibility of witnesses?
Right.
Maybe 10,
And what to
15
expect.
minutes.
Okay, the trial, you get into the trial now. Some of you were not in the courtroom for a long time because of your case, the mistrial. And you were there for about 4 days or 4 days before you were excused when the deliberation began.
Yeah, today was the fourth day, and I was excused after, well, you know, after instructions.
Did you have any problem, did anyone ask questions in your trial of the witnesses? You were allowed to ask questions?
Oh, yes. Yeah, I asked several questions, and they were,
You write them down?
I wrote them down. Everyone wrote them down. I think everyone I believe with the exception of one of the jurors, asked questions of some of the witnesses, yes.
And did you find that helpful?
Absolutely. I was thinking of that when I saw the film, that made a very big difference, and I felt, in my case, all the questions were answered, and the answer to one of the questions came up in closing arguments, and I just felt that I participated.
Mr. Hopkins,
I asked a lot.
you asked a lot of questions. And did you find that helpful?
Well, it helped me understand what was going on. Like they had one of the problems where they were describing a bar back. Okay, I wanted to know who that was. What was that? And they explained to me what it was. Somebody backing up a bar. And also about, it was like a wall with a shelf. And in my case involved a slip and fall. And I wanted to see what the shelf looked like. So they got pictures and showed us. And it helped
Good.
with the outcome.
Mr. Bradshaw, did your case last long enough to have any questions asked?
No, we took notes, but we never got around to asking questions.
Ms. Barnes?
Yes, we asked plenty of questions.
A lot of questions. So now I'm going to switch. How about Judge Marr, federal judge? Do you allow questions to be asked in your trials?
I don't invite jurors to ask questions. We don't tell the jurors that
They
they
can't?
can. I don't recall ever having, I haven't allowed it. There were a few occasions where a juror requested the opportunity to ask a question, and when I consulted with the attorneys, both sides agreed, no, don't ask any questions. They didn't want questions to be asked by the jurors. So I didn't, we told the juror, he or she, I forget who it was not going to be able to ask any questions.
So I have demonstrated to you, perhaps with this random selection of jurors, that jurors like to be able to ask questions.
Yes.
You're unaware of anything in the federal system that prevents it, right?
No, it's permitted. The 11th Circuit specifically says it's discretionary with the trial judge to allow questions if he or she wishes.
Okay. And would you consider doing it in your next civil trial?
I would consider it, and I would also want to know what the lawyers, what they thought about it before I
So
would
let me
allow.
ask the other judges. It's very interesting. When I got into this, I figured that the real innovators were going to be the federal judges, because they're there for life. They don't have to make anyone happy, including the lawyer. Their job is protected, and they are totally independent. The state judges, and I don't know whether your judges here are elected or have to stand for re-election or something like that, but where I'm from in Texas, they're elected. State judges around the country are much more innovative than federal judges. It's an interesting, I expected the opposite, that the state court judges would be much more concerned about asking the lawyers permission to do things. The federal judge would say, I don't need your permission, I'm gonna do what I think's right. But it's not true, it's the opposite. The state judges are much more attuned, and I think it may be because jurors are the voters. I don't know what it is. Why are state judges in this country more innovative?
Well, I can't speak for the rest of the country, obviously, but here in Florida, we have Florida Supreme Court approved jury instructions that expressly address that.
Questions.
Yes, and I encourage jurors to, and in fact, I'm sure we all provide pads and pens with which they can ask these questions. And in point of fact, we have them ask, when the question is asked, if it's an appropriate question, we then give the written question on the piece of paper to the clerk for the.
Judge Curley, you allow questions, right?
I allow questions. Mr. Schnur was on my jury. Excellent questions, by the way. They were good. I do, as to the innovation, I think it's a byproduct of, I as an example, have 1,500 cases. You'd better be innovative. You've got to do things to move it along and get people to trial. You didn't talk about delay being an issue, but I think it is. Quicker trials would make people want to try cases more often.
So let's talk about that. What do you mean by delay?
How long does it take to get to a trial in your jurisdiction? If you can get to a trial in 6 months as opposed to 3 years, doesn't that change the equation?
Of course.
Okay.
So you would be a proponent, and this is a big problem in the country, you would be a proponent for giving the lawyers an early trial setting and telling them what that's going to be early on in the case?
Mm-hmm. But got to be ready.
Got to be ready. Justice Gorsuch made a speech before he went on the bench where he said, I don't know where he got the statistics, but I suspect it's right, that 90% of the cases that are set for trial in this country get continued. And, you know, the lawyer, I know as a trial lawyer for 50 years, my whole lifestyle is based upon working in a system where no dates are definite. You know, everything's continued. You can get part of the civility is you got to ask the other side for to change a date, and they're supposed to give it to you.
Well, Steve, did you agree to the trial date? If you come in and you said, I'll be ready, and this is the date, and the other side says this is the date?
It's a real date.
It's a real date. You agreed to it, and I'll remind you of that when you try and continue it.
Do any, Judge Artau, you allow questions, I mean, you not only allow questions.
Well, not only do I allow questions, but the law requires us to allow questions. So it is institutional in our legal rules that we are in civil cases to, every time there is a witness in person, at the end of the testimony, we turn to the jurors and I outline in advance the procedure for them to ask questions. There's a special form that I give them to fill out the questions so that they know in advance that they're going to be asking questions should they wish to. And they are routinely asked after every single in-person witness. Obviously, if somebody's testifying by deposition, you can't ask a question of a deposition. And in criminal cases, I think it might be discretionary because of the fact that there might be some constitutional implications regarding the accused. But in civil cases, it is required that we ask those questions.
Back to the jurors. One of the problems I sense by looking at your answers to questions, and clearly obvious in the questionnaires the jurors fill out on our website, the biggest single problem is that most trials last longer than they should, and that most lawyers are repetitive. There's too much stuff. Everyone that I talk to says the trial could have ended 2 days earlier. In your case,
Well,
a lot earlier.
In my case, they were not prepared. Both attorneys would come in both days, and you just felt like they were flustered, and they were looking for things. They took 15 minutes to look for one piece of paper, and they would bicker back and forth. It was just very unprofessional all the way around.
I was the trial judge on that one.
What?
I was the trial judge in her case.
And he
You-
tried his best not to be unprofessional with them.
So you were the trial judge in her case.
Yeah, and I have another juror in the audience for a different case. So I'm very proud that I had 2 jurors come after the invitations, right? Mr. Costas is back there, right?
So Judge, one of these jurors told me that, I don't know what, one of the questions, I can't keep the questionnaires, that there were a lot of sidebars. Do you allow sidebars?
Of course.
Of course. Well, that's not an answer that needs to be given, obviously. There are judges in this country that tell the lawyers there will be no sidebars. If you have a problem, you raise it before court begins, or raise it at lunch, or raise it when court adjourns in the afternoon. So
Well, then how are you going to address a legal argument that the jury is not supposed to hear? In other words, the law requires that we are the trier of the law, and that they are the trier of the facts. So any extended argument beyond a 1 or 2 word objection needs to come to sidebar. Otherwise, you're going to end up with a mistrial, and then you're going to have to do this all over again. So I don't know how you can. I do realize sidebars get abused, but I don't know how you conduct a trial without it.
I guess you could tell the lawyers that there will be none, so if you anticipate there's going to be a problem, and I expect you to anticipate problems, you better raise it before court begins in the morning or in the afternoon after it's over, because otherwise you can make the objection and I'll rule the best I can. I'm going to listen to a little of it, but you're not going to be able to give me an oral argument while the jury's sitting there. You could do that, of course.
I don't think so. I don't think you can do that and properly administer a trial and tell the lawyers that they can't, that we're not going to have any sidebars and ruling on legal issues, because we cannot have those extended legal arguments done in front of the jury. I think that would either result in a mistrial or a reversal on appeal.
Okay. How about, did any of you find, well, what happened where any of you kept waiting in the jury room for lawyers to show up in the morning? Did that ever happen? I mean, or jurors to show up? I mean, did you find, were any of you annoyed with spending time waiting in the jury room? Thanks for coming.
Yeah,
John.
I got a verdict. You can call.
Any,
Thanks so much, sir.
thank you for coming. Did anyone have a problem spending, thought they were spending unnecessary time?
One of the jurors every day was late.
One of the
It's
jurors.
annoying, very annoying.
All right.
Um,
I've thrown him in jail.
No, we all love the jury room. We love our box with no windows and fresh air.
You
and
love the
coffee.
jury room?
No, I'm being facetious.
Did any of you, the judge, one of the things this film talks about is the fact that people learn after they go to a class about talking about what was just said. I didn't hear what the professor said. Did he say something about this? Could you understand what he was saying? Jurors are instructed by the judge, you all were, that you're not to talk about the evidence, even when you are together in the jury room, until the final deliberation. That you're not to make up your mind until you hear all the evidence. But in some places around the country, judges are experimenting and court systems are experimenting with allowing jurors to discuss the evidence when they are all together in the jury room without taking, they can't vote, they're instructed they're not supposed to make up their mind. Would you have liked the opportunity to discuss? You would have. Well, you weren't even the final deliberation.
Yeah, but we had lots of breaks and opportunities to discuss. But no, I think it was handled the way it should have been. And actually, the breaks we got a chance, it was very important to me to get a chance to know the other jurors just socially and without discussing the case. I felt very comfortable being prepared to go into deliberations, before I found out I was the alternate.
Mr. Hopkins, how about you?
It's about the same. I agree with him.
Okay. All right. Now let's see, who got to deliberate? You deliberated, and we had two of the jurors got to deliberate. Did you have any problem at all with understanding the judge's instructions?
None whatsoever.
They were clear.
Very clear.
Did you have any questions that the jury sent to the judge during deliberations?
No.
Let me ask the judges, have any of you used time limits on trials, where you set time limits? You haven't?
Not everybody.
Judge Gillen, what?
No, I have neither.
Judge Sasser?
No, I haven't used specific time limits, but we keep on a strict schedule. One of my jurors is here, and we started on time, we ended on time, and, and I think you can take a lot of issues on the sidebar before or afterward. So I'm always cognizant of the jurors' time schedules.
Judge Arto?
You can set, if the parties know in advance, you can set limits on openings and closings. But you really can't, the cases that come out of our appellate districts really don't allow us to put time limits on the, while we can prod the lawyers to move it along, on the actual questioning of the witnesses. So if we were allowed to do that, I think that it would make for a much more efficient process, because jurors complain a lot about lawyers being repetitive, and a lot of the feedback I get from jurors on the questionnaires that I give them is the lawyers are repetitive, they ask repetitive questions, and the like. So there's a fine balance there, but the law doesn't really allow us to put time limits on the actual evidence itself.
Let me just kind of throw in a little caveat to that. I have on more than one occasion, knowing full well that I had another trial that was going to start the next Monday, made it very clear to the lawyers in a case on Thursday that they were going to finish that case by Friday. We're going to get it to the jury for deliberations, or there'd be a mistrial, because I wasn't going to inconvenience the litigants and the lawyers and the prospective jurors in the next case because they were going a little too slowly.
Well, that's a time limit, right?
I'm sorry?
That's definitely
So
a
in
time
a sense, yeah, I suppose it's a time limit, but I didn't set it ahead of time.
All right, well, going around the country talking about time limits is, if we're concerned about the expense of trials and they're lasting too long, time limits is one cure to that problem. Because, and most lawyers who participate in a time-limited trial where the judge says you have 10 hours or 15 hours, love the experience. It's a better trial. You try a case better because you carefully select the witnesses. You don't repeat yourself unnecessarily, and so on. Did all of you work, when you came to the courthouse, did you work regular? I mean, your trials were so short in a way that you didn't have the problem. What hours, did you work regular hours, like from 8:30 in the morning to
5, we were all up.
5 in the afternoon? And what were you're shaking your head, Mr. Hopkins?
I'm retired, baby.
Didn't bother you?
Not one bit.
Okay.
If I could just address the question about time limits. I'm not a judge. It's just that our trial, civil trial, it was an automobile accident, and the medical, there were dueling doctors, and the medical testimony was challenging. And if if the attorneys had time limits, I think it might have given the jury problems.
Did you have experts in your case, Ms. Burns?
No.
Do you have experts in your case? Would it have helped an innovation that's being suggested in some places in the country that and the judge has the power to order the witnesses, can order the trial, and to have experts testifying back to back. I mean, so you hear one expert, then you hear the next witness is the other expert. So you can compare what they're saying better.
Our trial was short, so it was, and
didn't
a
know.
lot of it was out of order, so that actually pretty much happened. But yes, I think that was an advantage.
Okay. Let me ask, in your deliberations, Mr. Hopkins, how was the foreman selected?
Must have been the first one called.
Hmm?
The first juror picked.
The first juror picked was the foreman?
Yeah, I think so.
Ms. Bourne?
We chose age over beauty.
And, of course, you
I was
never
on
got
the-
there. You don't know who the foreman was.
We had a really good rapport. I really enjoyed meeting those people. They'll get a kick out of this today.
Did, and the two of you that actually went into deliberations, did each of you get a copy of the judge's instructions at the end of the case?
Yes,
Everyone got their own copy
yes.
Yeah, I did too. I stayed long enough that I
to get
did,
that.
yeah.
Did it include a verdict form?
Yes, it did, which
Every-
were collected before deliberations.
Judge Maurer, do you give each of your jurors a copy of this?
I send one set of instructions to the jurors. If they request each copy, I'll provide them to them, but usually one set is provided to the jurors.
But you would be willing to,
If they requested it, yes.
okay? Do each of you the state court judges, Judge Arto, Judge Sasser, do you give every juror a copy of the charge?
Every juror gets a copy of the instructions. Every juror during closing arguments gets a copy of the verdict form. When I send them back for deliberations, there's only one blank verdict form amongst the 6.
I follow the same procedure.
Yeah, and so do I as well. I think it's helpful because otherwise, if you send out one copy of the jury instructions, invariably that person ends up being the foreperson, whoever's holding the jury instructions. So if they each have the jury instructions and one verdict form, it's more equitable in how they determine who the foreperson is.
Right. I think that's what we would encourage everyone get. So have any of the judges given given substantive instructions at the beginning of the case? Here are the elements of the here are the elements of the cause of action, the claim. Yes, sir.
Well, the only reason that we don't do it in every single case is because the lawyers aren't ready with the jury instructions. And in other words, they are told to have the jury instructions ready to meet in advance, and there's a disagreement over what the law is. And so until we can have a charge conference, and so as to not delay the jury any further and have this charge conference in advance, since they're not able to agree, then I can only read to them that which is agreeable at that point in time. So I read to them at the very beginning, before opening statements, whatever law both sides agree to, plus the general instructions. And then at the end, after I've resolved it at a charge conference, then I read the rest of it. And we tell them in advance, there may be a difference between this and the final ones, but don't worry, we'll give you the final ones. Those are the ones you need to follow, and you'll get them in writing at that point.
Okay. Jurors, did you think the lawyers in your cases were equally matched? Ms. Bourne?
Sorry. No, one was, he did not come across as not just well prepared. I just didn't feel like he came across very educated.
Okay.
So I'm way too emotional. Guys, don't cry. Don't cry. Yeah.
Mr. Bradshaw, could you pull the mic over to you?
It was only 2 days, but I felt they were evenly matched.
Mr. Hopkins
Very evenly matched.
and Mr. Schnarr.
Yeah, there were 3 really who interviewed witnesses, and the medical knowledge, obviously, they were very well versed, all of them.
What single thing would you have us do to make the experience better for you?
Again, as I mentioned, it was a wonderful experience. I want to state that, really. I mean, I've never served on a jury before, but I've been called before, and in an unnamed state. We were sitting there waiting to see if we'd be pointed to a case and impaneled or through voir dire, and we could not bring a newspaper, we could not look at our phones. We were ordered this way and that way on hard metal chairs. This was very welcoming and respectful. I've told my wife, I've told friends already, just what a difference, and encourage them to participate. But I wouldn't say a problem. I'd say the most challenging part of the experience was understanding all the medical testimony, and there were MRI images and CAT scan images, and I would have, if I got to deliberation, I would have certainly depended very much on the other jurors.
Mr. Hopkins, what single thing, if you could change anything, what would you change?
Probably more comfortable chairs.
Better chair. That's a fair comment.
I have old chairs in my courtroom. I'm really sorry. We don't have new furniture yet.
Mr. Bradshaw.
I would say the same, chairs, a little bit more comfortable. But overall, the whole experience was great. I enjoyed it.
And Ms. Bourne.
Very enjoyable experience. Very impressed with the process in Palm Beach County.
Yeah.
Overall, I would just hope the judges could help encourage them to be ready, which he did.
Judge Meyer, how long have you been on the bench?
Federal bench, 16 years, and before that, on the state court bench, 6.5.
So you don't quarrel with, I mean, you accept the fact that the number of trials is diminishing in this country, right?
I accept the statistics.
Yeah,
I'm trying cases all the time.
Oh,
so-
but I mean, what's your explanation? What do you think are the reasons why there are so few trials?
I assume because the parties resolve them.
Well, then I got to ask, why do you think they are doing that? Why are the parties not taking these cases to trial?
Because they rather have the burden of hand is worth two in the bush.
But that's always been the case, right? I mean, that was true in 1965, 66, when I began.
It wasn't as expensive to litigate in those days.
Do you think
And I
it's
think
really?
the
Do you think it's
cost of
been?
litigation and the prospect of having to spend the money to get to trial versus settling early on, I think is a determining factor.
Judge Gillen, what do you think?
Well, I agree essentially with what Judge Mara is saying, but one problem that I run into, in fact, this week is a perfect example. I had a trial that was supposed to go for all 5 days. Last minute, I had an agreed upon motion for a continuance. I won't get into the reasons advanced for the continuance, but then when I tried to call up the backups, oh, we can't do that on such short notice, Your Honor. I said, well, yeah, but you knew you were a backup for this particular time period, and you were only for 3 days. Why can't I get you on starting on Tuesday or Wednesday? We can finish up for the week. No, I couldn't do it. Neither of the backups were able to do it. So that is definitely is a factor.
Judge Sasser, what do you think are the? I know you've been thinking a lot about this.
I have, and I agree with Judge Mara. I think the expensive litigation that's something that that people are taking into account, and cases are resolving and early on, or forced arbitration. That's what I anticipate. We do try a lot of cases. I agree with Judge Mara, and I think we're special here in the Southern District and in Palm Beach County. I've tried over 100 in the 8.5 years I've been on the bench. I've tried 150 civil jury trials. So we try a lot of cases. We're very fortunate. Maybe we're unique. I don't know.
That is unique. Judge Hartow.
I mean, I call up trials every single week for trial, and if that one settles, I call up the next one, and so I try to be in trial as often as possible. I have not seen in the 4 years that I have been on the bench a decline whatsoever with regard to jury trials I find it to be very steady. I have certain gaps where everybody seems to be settling and or wanting to, or not being ready for trial and having reasons why a continuance might have to be granted. And then periods where it's one trial after another, week after week after week, I'm in trial. And so I have found it to be fairly stable, fairly steady in the division that I'm in. I don't think, I think that I disagree with the list. I think that you promulgated most of the things in the list. I think that the primary reason why overall these general statistics that are more national in nature is because we have put more of an emphasis on alternative dispute resolution, mediation. It's been more professionalized. Mediators have been, in most states, certified by the Supreme Court, required to have a license to be certified. Every single case gets at least one referral to mediation. And I don't think that's a bad thing. And I think mediation has been successful. And because it has been successful, more cases settle, perhaps, than used to go to trial. And that has a lot to do also with, as my colleague said, the expense of it. But I think that's the primary reason, and I don't think that's a bad thing. And I don't think that, I think the right to jury trial is alive and well, definitely here in the 15th Judicial Circuit, and we honor it. And it's certainly not, I do have a very strong disagreement with what was mentioned earlier on the list about insufficient judicial education. Both Judge Sasser and I serve on the faculty of the judicial colleges in this state, and we have lots of judicial education. Our state trial judges know how to try cases. We teach them how to try cases, and they do an excellent job trying cases. And I do not think lack of judicial education is any reason why that would have contributed to any of these statistics. Okay. But I do think the alternative dispute resolution is the primary reason, and I don't think it's a bad thing.
Let me now, in the next few minutes, ask whether the audience has any questions of the judges or the jurors. Yes, sir. Would you stand up, please, so we hear you?
Has there been any experimentation with allowing jurors to ask questions at the conclusion of attorneys' closing arguments? And how does the panel feel about that?
Judges, I don't think there's been much. I've heard about that. It's probably a good idea. But I don't know who's doing that. Judges, what do you think of that as an idea?
I've never heard it done. It's an interesting concept.
It is. Have you heard it done anywhere?
No, I have made an effort to arrive at a stipulation of closing counsel.
Questions after closing argument.
All right. Yes, sir.
The burden of proof most often, I want to make sure all the questions get answered. I want to know what the questions are, and I want to have an opportunity to answer them. The procedure would be the same as questioning witnesses. You write the questions down, the court reviews them to determine that they're appropriate. Both sides have an opportunity to address the questions.
Mr. Hopkins.
Well, I was on jury duty up in New York after the case was closed and everything. The judge and all the lawyers were outside in the hallway, and they asked questions, and we asked questions of them. And it was satisfying.
Any other questions? Okay, well, thank you very much for coming. When you leave today, you will get a survey about whether you liked it and what can be done to improve this lunch, and whether you want to do another one sometime. Thank you very much for coming. And thanks, judges and juries. Thank you very much.